Hello everybody. So this is my third of three videos for today. Today I'm talking about Proposition 11, or at least this evening I'm talking about Proposition 11. Here's the deal with Proposition 11. I have a lot of friends who are EMTs. They hate it. They want it. They're definite no votes on it. I have other friends who are definite yes votes on it. I'm just kind of looking at this thing. I don't really know. My recommendations on votings are on how people should vote kind of connect to my belief in their ideology and also in their kind of interests, right? And so I think this thing has a lot of claims that aren't true, and I think there's a lot of unsubstantiated claims, and we're going to go over it and explain why there's just kind of a dearth of evidence one way or another. So let's do a little bit of history here. So back in 2012, the California Supreme Court decided in the Brinker case, that on-call meal breaks were forbidden. As part of their decision, they based it on a California Code of Regulations wage order from the IWC, which is I think it's the State Industrial Wage Commission. Right, and that specific section 12A specifically said any meal break that is not a free meal break where you don't do work isn't really a meal break. And then Labor Code section 226.7 prescribes a 1 hour penalty for every day the employee is not given a meal break. So you don't give a meal break for 1 day, you get an extra hour of penalty that you have to pay the employee. So the employee gets an extra hour of a day's wages, right? So this litigation, so in 2016, in ABM Security Services, the Cal Supreme Court dealt with a very related question, which is how do you deal with the question of rest breaks, right? Not just meal breaks, but rest breaks. And the California Supreme Court unanimously decided that essentially rest breaks also have to be on duty or off duty, right? And the argument that ABM brought forth, and it's a security service company, was, hey, look, we need these guys to have their pagers on. More importantly, the meal break rule had a very specific sort of exception or a very specific statement that any sort of work done during the meal break wasn't really work. So therefore, since the rest break sections of the regulations don't include that specific saying, therefore rest breaks can be on duty. Well, the California Supreme Court said no dice. They viewed the absence of any permission one way or another as telling, given the dictionary definition of the word rest. And it may surprise some people, but lawyers do actually use dictionary definitions for words. Right, so they basically said, look, rest is the antithesis of work. There's no specific carve-out allowing there to be on-call rest breaks. Therefore, those on-call rest breaks don't exist or cannot exist in California law. They do not constitute a rest break. And in California law, for every, I think it's like 5 or 6 hours that you work, you have to have a 30-hour or 30-minute meal break. And then for every 2, you have to have a 10-minute rest break, right? So everybody has to follow those rules. And people can't be on call during meal breaks or rest breaks. And the rest breaks was the most recent decision that kind of set off a flurry of litigation, right? Because at this point, then, AMR employees were like, well, wait a minute. Because traditionally, EMTs were told to kind of have their phone handy. Right, and the California Supreme Court in 2016 specifically said on a 6-1 vote that having your phone handy constitutes work, right? Because the whole point of having your phone handy is to get a call to come in and to do work. So, based off of that litigation, AMR found itself kind of subject to the same type of litigation, and it's pretty clear AMR is going to lose, right? As things stand right now. Right, AMR, much like ABM, is a very necessary security company, a health company. They provide paramedics, right? They're needed, And if it didn't kind of help ABM in its argument, it's not going to help AMR, right? They would lose the suit. So here's what they decided to do. They said, look, let's pass Prop 11. Let's get Prop 11 in the ballot. Here's what Prop 11 does. One, and this is unrelated, it tells us that we have to fund, employees' trainings for certain various things. Okay, that's the first thing. Second thing, in terms of rest breaks, it defines a rest break and a meal break as being exclusively free from employer control. And this is where some misinformation starts to happen, right? The claim made by the opponents of Prop 11 is that this thing effectively neuters any meal breaks whatsoever, and that under the law you couldn't have a meal break for any reason, right? That's not true, right? As a matter of fact, under Prop 11, if you're called and you have to work during your meal break or your rest break, it's not constituted as a rest break. Prop 11 also says you can't have your meal break within 2 hours of your work, right? Therefore, you don't have to starve for 6 hours, right? So Prop 11 says, look, a meal break is one where you do not have to do any work. However, we define a meal break, we define not working as not actually working. We define being on call as not working. In other words, as if you are on call during your meal break, right, and you don't get a call to come in, this is what the law effectively does, then your meal break has been satisfied. But if you are on call during your meal break and you do have to come in, you don't get a meal break, right? What that means is your meal break obligation hasn't been satisfied and you get a later meal break. So this doesn't do what people think it does. It doesn't say no meal breaks for EMTs whatsoever, right? It doesn't say all meal breaks have to be a situation where you have to be ready, rearing to go. It just says that all meal breaks, you got to have your phone handy. But if your phone's never used, if you finish your meal break, then you're good to go. And if not, and you don't get a meal break, then they're still subject to the penalties. That's a little bit of a different thing. Now, I do agree with the opponents of Prop 11 that yes, there's some chicanery afoot here. So there's a specific carve out that says that this statement, the thing I just told you, isn't a change of the law. It's a declaration of existing law as it existed on October 25th, 2017. Of course, the AMR litigation is still pending, and of course, declaring what existing law is would necessarily affect that litigation. Effectively, what it's trying to do is it's trying to modify the Supreme Court's decision. But, and this is where I part ways, I don't think it would lead to the major windfall for AMR that people think it would. So, the premise of the suit right now is all these EMTs were told to have their phones handy on them, right? And because they had their phones handy on them, they did not get a meal break or a rest break. And therefore, they are entitled to the wages that entails, which, as I mentioned earlier, is basically you get an extra hour of wages per day that you didn't get the break, right? Their argument is just having that phone constituted work. 6 out of 7 justices in the Supreme Court agree with them, right? Which is clearly enough, right? So 6 out of 7 Supreme Court justices say, yeah, look, that constitutes work, which means in that civil lawsuit, even if they didn't actually answer the call, they could be compensated for just having to have their phone on them. Okay? Here's the deal. The way the law sets out is it says, look, we define work as having actually been on call during those breaks, and actually having answered a call during those breaks, not just being on call during those breaks, right? So what would inevitably happen, as that's now the existing law, is the employees who actually had to answer the calls and never got a subsequent meal break or rest break, right? They would still be entitled to compensation post Prop 11 because they answered the call, and under Prop 11, that's still defined as work. Okay, so the problem. Sorry, my verbal filler is either right or okay. You may have noticed that. Don't take that as any sort of statement of arrogance or whatnot. It's just kind of my period in my mind. So when we're talking about what the lawsuit will effectively do. AMR will save money, but they may still have to pay out a lot of money, right? It's ultimately a fact question, and I don't know the answer because I don't know. And this is what I was talking about, the incomplete evidence earlier on. I don't know how much information, how many employees have had to actually answer a call, and were not duly compensated, right? Prop 11 passes, those employees still get extra money. They still get the money that they're owed, coming from AMR. That this law will not change that balance at all. Some people may think it will, but it won't, right? It's very clear. That being said, the main proponent, the main argument behind this litigation, or behind Prop 11, is we need to reduce wait times, right? We need to reduce ambulance wait times to get from one place to another. And in support of that argument, they said, look, in rural counties, sometimes it takes 30 minutes for an ambulance to get there. What they have failed to provide is any evidence that a meal break or a rest break will actually slow times, right? Prop 11 has a carve-out in it, not a carve-out, a requirement in it that AMR and every other paramedic staffing agency have enough staff to answer calls at each and every time, right? That they have enough staff so where they don't, they can handle a break, they can absorb a break, right? So if that's followed through, the chief evil, right, can be ameliorated that way, and it may not even affect paramedics, right? Because if they do fully staff and they do have people that are going to be on work during those times, then maybe the paramedics that get a meal break and a rest break won't have to worry about their phone being on, right? So that's the kind of the hope. But what's missing for me from the Yes on 11 crowd is how much of a delay in wait times are we going to experience because of this, right? It's entirely speculative. There's no evidence on it whatsoever, and I understand why. It's because this hasn't been allowed to happen before, so there's no data supporting it. But if AMR has adequately, staffed their agency, then theoretically this shouldn't be a deal. Like rejecting Prop 11 shouldn't change the fact that AMR has adequately staffed their agency, and therefore shouldn't change the fact that they can respond in an adequate manner, right? I get the argument that by passing Prop 11, you're decreasing the risk of people dying, right? Because inevitably the quickest people are going to go there. But that is a 1% solvency argument that I'm not sure about, right? Without any more evidence suggesting that that's the case, I'm doing something that clearly will benefit AMR, although, like I discussed, not as much as the opponents of Prop 11 would like to say. I don't know. Your mileage may vary on this, right? If you think that evil is so finite and concrete as to necessarily be avoided by passing something that makes sure that there are people on call, great. Then you should pass. Then you should say yes on 11. But if you feel like AMR is essentially getting away with something based off of a speculative and unverified fear, then your answer should be no. Even if AMR is getting less money, they're still going to get, or paying out less money. Let me rephrase that. Even if AMR is still paying out money, they're paying out less money, right? So there is still, AMR still benefits, even though I don't think they're going to benefit nearly as much as people think they will. But again, that misses facts too, which is how many employees were actually working when they were on call during their EMT period. I don't know the answer to that question, right? If that answer is so incredibly high, then this litigation ironically does nothing. The proposition will do nothing to change the balance of that. Nothing. Because those people are still working as Prop 11 defines the law, right? The only people that wouldn't be paid out are people who had their cell phones on but did not have to actually answer a call during the work period. Those people would not be paid out by AMR. But the people who still did work, right, would be paid out. And so if that fear, if that anger is more compelling to you than the admittingly speculative fear that people may not get to 911 patients in time, then you should vote no on this bill. So in short, it really your decision probably should come down to a couple of things. One, your assessment of the likelihood of slower response times, and two, your comfortability with the fact that AMR will get some sort of windfall from this. Even though, and this is kind of 2A, I really want to stress that it's not going to be the windfall that people think it will be. Right? Some of the arguments I've seen on Facebook are not accurate, based off of how this law tries to go about insulating AMR. So, at the end of the day, that's your call. I mean, these are all your calls, right? I don't have a definitive recommendation. I mean, yeah, I voted on it one way or another, but I mean, my vote is as much of a coin flip as yours. So, anyway, at the end of the day, thank you for listening. Tomorrow morning or tomorrow midday, I will do something on Prop 12, and then I will do an election prediction video. So, thank you very much.